Good afternoon. My name's Robin Meadows, and I'm the interim dean here of Widener University School of Law in Harrisburg, and I want to welcome you to the 9th annual, yes, it is the 9th annual John L. Gedid Lecture. And how quickly time goes, right? I remember when the first one happened. And we are thrilled to be joined today by faculty and students and staff and alumni and friends of Widener to share in what will be, I have no doubt, a wonderful lecture by Professor Tara Grove. I am now going to turn it over to Professor Jill Family, the director of our Law and Government Institute.
Thank you and welcome. And as Robin said, this is the 9th annual Gedid Lecture, and this lecture series honors John Gedid, who's with us right here. Raise your hand. Who's one of the founders of our law school and is also the founder of the Law and Government Institute, an institute which I now direct. And these lectures celebrate the work of outstanding young legal scholars, and they also celebrate John Gedid's enthusiasm and support for our law school and for developing legal scholars. The Law and Government Institute, which I said John created, sponsors this lecture series and is dedicated to the study of government law. The Institute is dedicated to the study of how government works, including the role of lawyers in government. Lawyers are heavily involved in the function of government. They provide legal advice to the governor, they write legislation, they represent clients before state agencies. And at Widener, students may earn a certificate in law and government that provides them with hands-on experience learning about the role that lawyers play in government law. And if you're interested in learning about more events that are sponsored by the Law and Government Institute, the best way to do that is to follow the Institute on Twitter. And you can follow us at @WidenerLG. That's @WidenerLG. We're so glad that John Gedid and his wife Carol are here with us this afternoon and that they've been able to celebrate these lectures with us. And I have two small tokens of appreciation for all of their support for the law school and for the Law and Government Institute. And so for Carol, we have some spring flowers. And then for Professor Gedid, what we do every year is we have our speaker, our lecturer, sign their flyer with a note to Professor Gedid. So this is the 9th flyer in a series of flyers with some nice handwritten notes from our speaker. So I'll give this to John. After the lecture is finished, please join us for a reception in the gallery, which is a room that's in this building. If you just head out this door and head to your left, you'll find your way to the gallery. We have a reception there with drinks and some hors d'oeuvres. Please note that we are recording today's lecture to be posted on the law school's website. There will be time for audience questions at the end. One of our students, Patrick Parsons, who's over there, he will have a handheld mic that if you raise your hand, if you have a question, he'll bring you the mic and you can ask your question. I also want to say a special thank you to Sandy Grafe, who works with the Law and Government Institute and provides us with invaluable help in planning and hosting these events. And now it is my pleasure to introduce you to our speaker. Tara Lee Grove is an associate professor at William and Mary Law School. She graduated summa cum laude from Duke University, which, by the way, congrats on the basketball championship, and magna cum laude from Harvard Law School. She clerked for Judge Garza on the U.S. Court of Appeals for the Fifth Circuit, and she spent 4 years as an appellate attorney for the U.S. Department of Justice. Professor Grove's research focuses on the federal judiciary and the constitutional separation of powers. Her award-winning articles have appeared in prestigious publications, including the Harvard, Columbia, and Penn Law Reviews. Today, Professor Grove will talk to us about a very timely topic, the executive's duty to enforce the law. Please join me in welcoming Professor Tara Lee Grove.
Thank you very much to all of you for having me. I want to thank Jill family for putting together a terrific program for me throughout the day. To Michael Domino, who I know couldn't be here but sent me the invitation email, and also to John Gedid for putting this together. It's a real honor to be here, and it's a testament to you that you put your time and resources into this. So my topic today is the executive's duty to enforce the law. To start out, I want you to imagine that in 2016, after the 2016 elections, a new president takes office and says, you know, there's this provision on the books called the Individual Mandate of the Affordable Care Act. I know the Supreme Court upheld it, but I've talked to a lot of people, and it seems to me that a lot of middle-class folks are suffering because of this individual mandate. They have told me that it is just really, really hard for them to go out and buy health insurance or else pay a tax. And so from here on out, January 2017, my administration will not enforce the individual mandate. My administration is going to study this issue for a while, figure out if it really does make sense to require people to buy health insurance, and until we decide that it's a good idea, we will not enforce the law. Now, can the executive really do that? Well, surely the answer has to be no. After all, we all learn, or most of us learn, in our high school civics classes that it's the legislature's job to write the laws, the court's job to interpret the laws, and the executive's job to enforce the laws. That's what it means to be an executive branch. In fact, our Constitution is even more clear about the obligations of the United States President. Article 2 of the Constitution states expressly that the President shall take care that the laws be faithfully executed. It couldn't be more clear on this point. Faithfully executing the laws cannot possibly include refusing to enforce the laws, can it? Well, what I want to suggest to you is that the issue is actually not that clear. The executive branch, in a variety of contexts, has to make choices to choose when and under what circumstances it's going to enforce the law. My remarks today will focus on a few different areas. First, the use of prosecutorial discretion in a variety of contexts. Second, the specific context of a situation where the executive has doubts about the constitutionality of a law. And finally, I want to come back to what's to be done when the executive, in our view, is not enforcing the law in a way that seems problematic. So on the first issue of prosecutorial discretion, I want to start out with a subject that's probably familiar to most of us, the speed limit. Now, I don't need a show of hands, but I'm guessing that at least a few people in this room, maybe most people in this room, have gone at least 1 mile above the speed limit. Yes? Maybe 2, 3, 4, 5, yay. So there's actually a road in Williamsburg, Jamestown Road, where it's 25 miles an hour, and I just can't do it to save my life. So when you go 1 mile or 2 miles above the speed limit, are you breaking the law? Absolutely. Next question. When you go just a couple of miles over the speed limit, are you pulled over? I'm guessing the answer for virtually all of you, if not everyone in this room, the answer is no, you are not. Because the executive is exercising its prosecutorial discretion not to pull you over. Well, why not? Well, as you guys all know, especially those of you who have experienced Interstate 95, there are hundreds, thousands of drivers on the road at any given moment. It is not possible for law enforcement officials to pull over every single person who goes just a little bit above the speed limit. They don't have the resources. They don't have the time. They don't have the personnel. So they have to make choices. They have to exercise prosecutorial discretion. And when you're a law enforcement official, how are you going to exercise that discretion? Well, you're probably not going to focus on the people going just a couple of miles over the speed limit. You're going to focus on the folks going 15, 20, 25 miles above the speed limit, the people who are truly creating a danger on the roads. We call this a de minimis exception. Some people are just not clearly enough violating the law that it's worthwhile for the police to enforce it. And what about within those people going 15 or 20 miles above the speed limit? Well, just imagine that someone's speeding down the road. The law enforcement official says, "Whoa, this person's going really, really quickly," pulls the person over. And the driver says to the law enforcement official, "Look, my sick grandmother is in the back of the vehicle, and I've got to get her to the hospital as quickly as possible. That's why I'm speeding." Now, the officer might say to that driver, "This is not the right approach for your ill grandmother. The better approach is for me to call her an ambulance, for me to give you guys an escort. That's the better way to get her to the hospital quickly." But I ask you, would the police officer give that driver a ticket? I'm guessing in many cases the answer would be no. For humanitarian reasons, the officer would say, I'm going to cut this person a break. I realize this person was violating the law, but I'm going to exercise my discretion not to give that person a ticket, because this is really not the kind of person our speed limits were designed for. Our speed limits are designed for people who are just out there creating a danger on the roads, not those who are just thinking about their relatives. So in that case, too, the law goes unenforced. Now imagine you're a police commissioner and you're in charge of hundreds, maybe thousands of police officers that are looking at roads every day all over a state or county. Well, you might want to make sure that your officers are kind of using the same general guidelines to figure out which people to pull over and which people to give tickets to. So you might make sure with lots of training, maybe some policy statements, that everybody's basically on the same page, that everybody's kind of treating the de minimis violations as something that's not worth pulling over, and everybody has that humanitarian exception or doesn't, depending on what the police commissioner thinks makes the most sense. But I ask you, if after all that training, all those policy guidelines, if it turns out that, say, in an area where the speed limit is 35 miles per hour, if it turns out that no one gets pulled over for going just 5 or fewer miles over the speed limit, is that the executive exercising prosecutorial discretion with respect to a 35-mile-an-hour speed limit? Or has the executive just rewritten the law to make the speed limit 40 miles an hour? The line between prosecutorial discretion, which most people find to be perfectly reasonable, and a refusal to enforce the law turns out to me not all that clear. And that's an important thing for us to keep in mind as we focus on some of the more modern controversies that have gotten a lot of attention as of late. So the first example that I want us to think about is marijuana enforcement. Now, marijuana is a subject that may be familiar to many people in the room. And I suspect that many of you are aware that in some states, it is legal to use medicinal marijuana. In a few states, most recently Colorado and Washington, it's also legal to use recreational marijuana in a variety of contexts. It's also, however, true that under the Federal Controlled Substances Act, it is illegal to use, sell, or even possess marijuana under any circumstances. There are no exceptions written into the Federal Controlled Substances Act. Marijuana is illegal in all circumstances. And the Supreme Court a few years ago held that Congress has the power to prohibit marijuana in all circumstances. And yet, the Department of Justice has said that in those states where marijuana is legal, either for medicinal purposes or recreational purposes, we won't make enforcing marijuana, the prohibition on marijuana, a priority. Now, the Department of Justice hasn't said we will never enforce the possession or use or sale of marijuana in those states. They've said it's a low priority. And the only times we will tend to enforce it are when, say, we hear that the marijuana is getting into the hands of children or being used by organized crime. So what the U.S. Department of Justice has done is created a list of enforcement priorities. And way down on that list is the enforcement of the marijuana laws in states that have legalized them. The question again arises, is this a reasonable exercise of prosecutorial discretion? Well, there are a lot of federal criminal laws on the books. The Controlled Substances Act itself not only deals with marijuana, it deals with cocaine, heroin. It regulates drugs all the way down to Advil to make sure that they are used and sold appropriately. So there are a whole bunch of other things that the executive branch could be doing other than enforcing the laws in states that have legalized marijuana. And going beyond the Controlled Substances Act, there are loads of other criminal statutes dealing with terrorism, dealing with white-collar crime. The Federal Bureau of Investigation has a list of 10 priorities that it updates every single year. Right now, counterterrorism efforts are at the very top of that list. Cyber terrorism is number 2. Going down that list, you see white-collar crime, civil rights enforcement. Drug crime doesn't even make the top 10. There are so many other things that the federal executive branch has to worry about. So, is this a reasonable exercise of prosecutorial discretion? Or has the executive rewritten the Controlled Substances Act to create an exception in states that have legalized marijuana? Another example is immigration law. This is a hot topic of today. According to some reports, there are around 11.3 million undocumented immigrants in the United States today. Now, there is no way the executive branch could possibly remove every single one of this 11.3 million people from the United States, even if it wanted to. There are not enough enforcement officials in the Bureau of Immigration and Customs Enforcement to do that job. So once again, the executive has to pick and choose. And one of the things that the executive has done recently, very similar to our speed limit example, is to say, look, we're going to set out some enforcement priorities. Also very similar to what the Federal Bureau of Investigation does every single year. What the executive has recently said is, here's a group of people who will not be an enforcement priority for us. They have, through what is called the DAPA program, DAPA, which stands for Deferred Action for Parents of Americans and Lawful Permanent Residents, through a program called the DAPA program, the executive has said, if someone is the parent of an American citizen or a child who has been accepted by the United States as a lawful permanent resident, we will not take steps to deport that person from the United States. In fact, we will be willing to give that person a work authorization for a limited time period. Now, this program has been greatly criticized in many circles, and in fact, the state of Texas has filed suit against the executive branch to challenge it, and one federal district court judge in Texas has enjoined the program, all based on the notion that this violates the executive's duty under Article 2, the duty to take care that the laws be faithfully executed. But this once again raises a tough question. Is this really a change in the laws? That's what Texas is arguing. You're rewriting the laws not to apply to parents of Americans or lawful permanent residents. But is that a rewriting of the laws? What the executive branch has said is, look, we don't have the resources to remove every single person from this country who might be removable. So they've said this is about limited resources and also for humanitarian reasons. What the executive is saying is it's not that different from the police officer who talks to the driver who's just trying to help out his family member. What the executive says is, for humanitarian reasons, we are trying not to break up families. So these are tough questions. And in some ways, the matter becomes even tougher when we look at another area where the executive branch actually has constitutional concerns about the law. So Article 2 of the Constitution says that the president shall take care that the laws be faithfully executed. And when many of us hear that, we think of the federal statutes written by Congress. But the laws also include the United States Constitution. And so when the president is told to faithfully execute the laws, he's also supposed to faithfully execute the Constitution, and for that reason, maybe shouldn't enforce a law that he thinks is unconstitutional. That looks especially to be the case when we look at other parts of the Constitution. Every officer of the United States government and every state and local officer takes an oath to support and uphold the United States Constitution. The president takes a special oath to preserve, protect, and defend the Constitution of the United States. And so what the executive says is, when I believe the law is unconstitutional, I not only may not enforce it, I cannot enforce it. And at various times in our history, executive officials have followed this approach. So just to take a couple of examples that are from relatively modern times. I suspect many of you have heard of Miranda versus Arizona, the Supreme Court's decision in 1966, where the Supreme Court says, before the police may question any suspect in custody, the police must inform that suspect, that he has a right to remain silent, that anything he says can and will be used against him in a court of law, that he has a right to an attorney. If he cannot afford an attorney, one will be provided for him. Many of us have these words memorized because we've watched Law & Order 24 hours of the day on cable. What many of you may not know is that 2 years after the Miranda decision, Congress enacted a law to overturn it. In 1968, Congress enacted a statute that said before the police question a suspect, they do not have to read the suspect any particular rights. They can question a suspect and get any kind of confession as long as that confession is given voluntarily. Why have we never heard of this law? Why are the Miranda rights so familiar to us? Because from 1968 on, for many decades thereafter, the executive branch, in Democratic administrations, in Republican administrations, refused to enforce that 1968 law. The executive's position, across party lines, was that this law violates the U.S. Constitution. This law violates an individual right against self-incrimination under the Fifth Amendment. So the executive said we should not enforce this law. And in fact, no one heard about this law at all until the late 1990s when a federal court of appeals, sua sponte, decided to bring it up. And in 2000, the U.S. Supreme Court declared its agreement with the executive branch. In 2000, the Supreme Court struck down that 1968 federal law. To take another example from modern times, not involving federal executive officials, but state and local executive officials. A few years ago, Colorado passed a law that significantly restricted gun ownership and transfers. The law required additional background checks for guns and also limited the sale of guns with more than 15 rounds of ammunition. Well, a group of sheriffs in Colorado said, we can't enforce this law. In fact, they not only declared an opposition to enforcement, they brought suit against the governor of Colorado to try to bar the enforcement of that law. Because they argued, yes, we have an obligation under Colorado law to enforce everything passed by the Colorado legislature, but we also swear an oath to support and uphold the Constitution of the United States. And in this case, we believe that this Colorado law violates the Second Amendment of the United States Constitution, which guarantees an individual right to keep and bear arms. So they said, we cannot support and uphold the U.S. Constitution by enforcing this law because this law violates the Constitution. Now, what the executive was doing in the Miranda context and what the Colorado sheriffs were doing actually has a long historical pedigree. If you go back in our history, it turns out that presidents have done this on various occasions when they think the law, often the law as interpreted by the courts, is simply unconstitutional. Take an example from one of William & Mary's own graduates, Thomas Jefferson. Thomas Jefferson was elected president in 1800 and took office in 1801. At that time, there was on the books a law called the Sedition Act. The Sedition Act was passed in 1798 and made it a crime for any person to criticize high-ranking government officials. Now, this law is anathema to us today. I think if you asked any lawyer in the country, that lawyer would agree that this law violates the First Amendment free speech clause of the United States Constitution. Well, that may be clear to us today, but it was not clear to Mr. Jefferson's contemporaries. At that time, in fact, the Sedition Act was viewed as constitutional by many, including by many federal court judges. In fact, every federal court judge to consider the issue had upheld the Sedition Act against First Amendment challenge. Well, when Mr. Jefferson took office, he said, I have a different view. I think this law is patently unconstitutional. And not only did he work with Congress to say that the Sedition Act would no longer be on the books going forward, but he also said, my administration will not prosecute anyone who violated the Sedition Act while it was in effect. Mr. Jefferson declared that he would not enforce an unconstitutional law. In fact, he said he could not enforce an unconstitutional law because it would violate his duty to preserve, protect, and defend the Constitution of the United States. Several decades later, Abraham Lincoln followed suit. In 1857, the U.S. Supreme Court issued one of its most infamous decisions of all time, Dred Scott versus Sandford. In Dred Scott, the U.S. Supreme Court declared that slaves were property, not people, and that slaveholders had a constitutionally protected property right in having their slaves, one that the legislature could not interfere with. Well, in 1863, as president, Abraham Lincoln did interfere with that property right. In 1863, President Lincoln issued the Emancipation Proclamation, which granted freedom to every slave living in the Confederate States. Now, what a lot of people don't realize is that at the time of the Emancipation Proclamation in 1863, Dred Scott was still the law of the land. Dred Scott would not be formally overturned until the 13th Amendment, which abolished all forms of slavery, the 14th Amendment, which granted citizenship and equality rights, and the 15th Amendment, which expanded voting rights. So in 1863, the Emancipation Proclamation was arguably unconstitutional if the U.S. Constitution is whatever the Supreme Court says it is. But that was not President Lincoln's view. President Lincoln believed that he had a duty to independently interpret the Constitution and to enforce the Constitution according to that independent view. And so President Lincoln said, "In my view, Dred Scott was wrong, and I'm going to act on my own view of what the U.S. Constitution means." Now, many of us might be perfectly happy to have let the Mr. Jeffersons of the world or the President Abraham Lincolns of the world decide what the Constitution means. We know they were extremely good lawyers, and we trust that they are probably going to make some pretty good decisions as compared to the courts. But we may not feel quite as comfortable giving every single state and local official that same sort of discretion to refuse to enforce a law that they think is unconstitutional because they might be wrong. And that's the real conundrum here. Once executive officials have the discretion to refuse to enforce a law on constitutional grounds, we might be perfectly happy with how they use that discretion in some contexts, but not all that happy with how they use that discretion in many other contexts. In fact, many of us might not be all that thrilled with the idea of giving the president that authority. Because just to play off my hypothetical from earlier in the talk, a president after the 2016 elections could come in and not only try to enforce the individual rights provisions that Mr. Jefferson and Mr. Lincoln were enforcing, but also other provisions. That new president could come in and say, "I know the U.S. Supreme Court declared the individual mandate of the Affordable Care Act to be constitutional, but you know what? I disagree. And I am going to act on my own independent interpretation of the Constitution, and I will not enforce that law." So once the executive has this discretion to independently interpret the Constitution, that may be a little bit discomforting in many contexts. And that's not just true in the constitutional context. When you think of all the other exercises of prosecutorial discretion, like the ones I mentioned earlier in the talk, many of us may be perfectly happy with a police officer who lets go the driver who's helping out the ill relative. I suspect that some people in this room, perhaps many people in this room, agree with the executive's position on marijuana laws, or agree with the executive's position on the immigration laws. But again, once the executive has that enforcement authority, it may be used in a variety of contexts. Just imagine a president comes in after the 2016 elections and says, "You know, that Endangered Species Act is really hard on business. And it also takes up a tremendous amount of resources. So from here on out, it's not that we're not going to enforce the Endangered Species Act, but my administration is just not going to make it a priority. And we're going to grant more and more businesses an exemption from the Endangered Species Act and focus our limited resources on things that I view as a higher priority." Once enforcement discretion is given, it's very hard to know how that discretion will be used. So finally, I want to come to the issue of remedy. What's to be done? How do we ensure that the executive uses its enforcement discretion for what we deem to be correct exercises of executive enforcement discretion, as opposed to those that we may view as not so appropriate? Well, some people believe the answer is judicial review. And that was the approach that Texas took when it sued the United States government over the DAPA program, saying that this Deferred Action for Parents program violates the Take Care Clause, and we believe the judiciary can figure out whether this is an appropriate exercise of prosecutorial discretion or inappropriate. The U.S. House of Representatives also believed in the judiciary, as it showed last fall. In the fall of 2014, the U.S. House of Representatives filed suit against the executive branch, claiming that its approach to the Affordable Care Act was a violation of the Take Care Clause and also interfered with Congress's legislative power under Article 1. Now, the current executive branch was not refusing to enforce the individual mandate, but was delaying enforcement of other provisions of the Affordable Care Act. And the U.S. House of Representatives argues in its lawsuit, you are overstepping, executive branch, and it has asked the judiciary to issue declaratory and injunctive relief. Many people believe that's the answer. The courts can look after the executive to make sure it's doing the right thing. But I have to say, I'm skeptical. As I hope you guys are beginning to see, the line between reasonable prosecutorial discretion and simple non-enforcement of the law is not at all a clear line. In fact, I want to suggest that it may not even be a judicially manageable standard. This may not be the kind of thing the courts can oversee. So if not the judiciary, then who? Well, Congress is always an option. Even if Congress can't bring suit against the executive branch, Congress has the power of the purse. Congress can withhold appropriations to the executive branch. Congress can reenact statutes, sometimes over the president's veto, in order to limit what the executive can do in terms of enforcement discretion. Congress also has the power to hold oversight hearings. And while some people don't think the oversight hearings are powerful, no administration official enjoys being hauled before a Senate or House committee to testify about what that administration official is doing. So oversight hearings can also be powerful. But I think perhaps the most important check on the executive, just as it is the most important check on the legislature, is the check of we the people. Sometimes we don't realize that the very first 3 words of our United States Constitution are we the people. The idea is that we the people wrote the Constitution, and we the people are the ultimate enforcers of the Constitution. And so we the people, both through opinion polls while a president is in office, and also through our votes at the polls on Election Day, we the people can ultimately judge whether the executive properly exercised its enforcement discretion. We the people can decide whether the president did take care that the laws were faithfully executed. Thank you.
We do have some time for questions if there are questions in the audience.
Karen Balaban, I'm a practicing attorney. I have 2 questions. Rather than a president deciding not to enforce something, why don't they veto a law?
So I think that's a tremendously important question. Sometimes the law came before a previous
Right,
president.
sure.
So sometimes it's actually the president never had the opportunity to veto the law. But I think you raise a really important point. If a president believes that a provision of a law is unconstitutional, the president should just veto the entire law. I agree with you. I think that that's the approach the president should take. I will say, however, that people have expressed concerns and reasonable concerns about that approach. That worked very well back in the 19th century when most laws had just a couple of line items on them. Today, many laws are omnibus laws, which are hundreds and hundreds and hundreds of pages. Many times they're appropriation statutes for important agencies like the Department of Defense. And what many modern scholars and presidents argue, and I think reasonably so, is that can a president really refuse to let all these other provisions go forward by vetoing the law based on the constitutional problems with one provision? This is an argument maybe in favor of the line item veto,
Right,
but that
right.
in and of itself has some concerns.
And my second question, when you said "we the people," well, what if? How do you know which thing the people are voting against? Because, for example, with Obama, you had the issue of the health care law, as Affordable Care Act, as well as the immigration. Or did he passed that after his election. That's right, the immigration thing. Yeah.
Right. So voting is not a perfect measurement if what you're trying to do
Particularly
is
since he's not facing re-election.
Right. If you're trying to send a message, I think the people can send messages in all sorts of different ways, which is one of the reasons I mentioned opinion polls. I think it does matter in terms of how much an executive branch can get done, what the latest opinion polls say. People also send a lot of messages through congressional elections, which happen every 2 years. They often send messages through governor's elections. In Virginia, the governor's election is always in an off year. And many times these other elections are also a response to what is happening in the federal executive branch.
What do you think about the effect of signing memos?
Signing statements. Signing statements are a really interesting development. I sympathize with the first questioner that wouldn't it be better for the executive simply to veto the law rather than issuing a signing statement saying, I am signing this law, but I have constitutional concerns about particular provisions. In my view, though, absent a veto, signing statements are actually quite helpful. Because I think it's more important, if it is true that the executive has constitutional concerns about a law, and the executive may be disinclined to enforce a law, wouldn't we the people and Congress rather know than not know? So I think because it's providing much more information, it's actually better if the executive's not going to veto the law, it's better that the executive provide some information in a signing statement. That may, however, also indicate the executive should have vetoed the law.
Is it too late? Voicing and articulating those concerns that he may have in enforcing it, is it too late to do it as part of the signing statement?
I certainly don't think it's too late, given that we've seen executive officials, presidents express constitutional concerns about laws years after they are in fact enacted. So a signing statement is just the moment of enactment rather than a few years later.
Sorry. So I'm struggling with two of your examples. The first one, I'm unable to come up with any way of distinguishing between a president, the current president, exercising prosecutorial discretion in the immigration context, and say a hypothetical President Cruz coming in and saying to the IRS, just put the enforcement of that tax penalty at the bottom. I've been sitting here since you started talking, trying to come up with a way of differentiating them. Do you have any ideas? I mean, you think about this all the time. Is there a way, or are we just kind of hopeless where we are right now?
The entire purpose of my presentation is to suggest that there is no way to clearly distinguish those. And that's what I think is the important thing for us to recognize. If we think it's great for the executive branch to have discretion in one context, we have to keep in mind that a future president will look to that as a precedent for similar action that many of us may not be as happy about.
Is it an impeachable offense? We've had situations in Pennsylvania where the Attorney General didn't want to enforce the Constitution. That when the constitutionality of the law is challenged, the Attorney General is supposed to support the position of the legislature. They elected not to, and the legislature threatened to impeach, but nothing's gone forward yet.
So the question is it an impeachable offense for a president to refuse to enforce a law? We actually have an example of a president who was impeached on that ground. So back in the Reconstruction era, President Andrew Johnson was impeached, and there were many, many allegations against him, one of which was that he had refused to abide by a law that said he had to get Senate consent before removing a federal official. Now, decades later, the Supreme Court declared disagreement with President Johnson and said it is unconstitutional for the Senate to require senatorial consent to removal. And that was the Myers versus United States case. But at the time that Andrew Johnson was around in the 1860s, it was not as clear. And so one of the arguments at the impeachment trial was, is this an impeachable offense? So the House of Representatives did impeach Andrew Johnson, and it went to the Senate. And we have reams of information from that Senate trial. Some people arguing yes, it is. Some arguing no. Some of you may know from history class, President Andrew Johnson missed getting removed from office by one vote. There had to be a 2/3 vote against him. So at least a majority of the Senate seemed to think that it was. I think that's still very much an open question in our law.
Professor, first of all, this was very fascinating. I really enjoyed the talk, and I appreciate it. I guess to follow up on what was just said, I also thought back to our Attorney General who chose not to defend a gay marriage law. And not that it's relevant. I think the gay marriage law was horrible. I'm glad it's been stricken down. But what troubles me is, as you talk, you can almost picture in your eye a group of people gathering and having an intellectual conversation and coming to a legal opinion that it may not be constitutional. Well, the reality is the people in the room may well be political advisors. You know, when they don't support a law or they don't enforce a law, it happens more often than not, I imagine, to be wildly popular with their political base. And so it takes, you know, the constitutionality of it is convenient, but for political purposes. And is there any way, I guess because they're elected officials, there's no way to take that out of it, but how do you separate the legitimate legal opinion from pandering to your base?
Of course, in Virginia Attorney General Mark Herring did something very similar with our ban on same-sex marriage. So many people view this as the compromise approach, in fact, enforcing the law but refusing to defend the law. This was the approach that the Obama administration took with respect to the Defense of Marriage Act, and the approach that various attorneys general around the country have taken with respect to state bans on same-sex marriage. What the attorney generals are saying is, well, we'll enforce the law. That means that someone will be injured by the law. That person will then have standing to sue in federal court because that person has an injury. And when that person goes to federal court, we, the executive, will refuse to defend it. Actually, what's happening in the same-sex marriage context, as in the defense of marriage context, the executive is saying not only we won't defend the law, but making arguments that it is unconstitutional. So basically, you have two briefs, one from the plaintiff and one from the executive, saying that the law is unconstitutional. And the idea is that this then allows the judiciary to decide if the executive was right. And there's a lot to be said for that approach. The executive does not appear to be making a unilateral decision, and ultimately the courts, and in many cases the U.S. Supreme Court, will decide what is the meaning of constitutional law. But if you believe, as Mr. Jefferson did, that the executive has a duty not to enforce a law that it views as patently unconstitutional, then what the executive is doing in those cases is violating its oath by enforcing a law that it believes is unconstitutional and allowing people to be hurt by that law. Because if the executive refused to enforce it, then couples could already get married without having to go through a lawsuit. I think this is a very, very difficult issue. And it really depends, again, on how much independence we want the executive to have and on how much power we want the courts to have. Because once that issue is kicked over to the court, they won't necessarily rule just in one direction. I think many people have a sense of how the court might rule on this particular issue. But if you expand that to various other issues, and it's ultimately the courts that get to decide on the meaning of the Constitution, many of us may not be all that happy with how that turns out in the end.
I think we have time for one more question. If not, please join me in thanking Professor Brown. And please join us. We'll be making our way over to the gallery for the